Good evening and welcome. My name is Kathleen Winters, and I'm the Executive Director for the Northern District Historical Society. A warm welcome to everyone joining us this evening, both in person and virtually. Special thanks to the generous co-sponsors of tonight's program, Arnold and Porter, Cachette Petrie McCarthy, the Federal Bar Association's Northern District Chapter, Kecker, Van Est, and Peters, the Morrison Forrester Foundation, the Ninth Judicial Circuit Historical Society, and Paul Weiss. We would also like to acknowledge Nancy Nishimura and Joe Cachette, whose generosity made it possible for us to hold the program in this beautiful space. Our co-sponsors and our individual and law firm members make this event and others like it possible. We are also grateful to Jared Augustus, Rosa Brenes, George Zavala of the Law School for their assistance and for recording the program. And we are grateful to law clerk Andrew McCreary, who provided invaluable assistance, stepping in multiple times to help with logistics. Finally, as with all our programs, Alex Murray of the NDHS took care of countless details behind the scenes. A few reminders: if you registered for CLE credit and are here in person, please be sure to sign the CLE attendance sheet before you leave this evening. And for virtual attendees, we will monitor your attendance online. And if you've not already done so, please silence your cell phones. As you know from our speakers' biographies, we have a stellar panel with us tonight. Were I to list all of their accomplishments, we would not have time for the discussion, so please excuse the brevity of my introductions. Our moderator is Judge Rita Lynn. Judge Lynn has served as a district court judge in the Northern District since 2023. Prior to that, she was a Superior Court judge in San Francisco, an assistant U.S. attorney in the Northern District, a litigation partner at Morrison and Forrester, and a clerk for Judge Sandra Lynch of the First Circuit Court of Appeals. Erwin Chemerinsky is next to Judge Lynn. He is the Dean and Jesse H. Chopra Distinguished Professor of Law at UC Berkeley School of Law. Prior to assuming this position, he was the founding dean at UC Irvine School of Law and a professor at Duke Law School, USC Law School, and DePaul Law School. He is the author of 20 books and over 200 law review articles. He frequently argues appellate cases, including in the United States Supreme Court. Pam Carlin is next to Erwin. She is the Kenneth Montgomery Professor of Public Interest Law and a founder and co-director of the Supreme Court Litigation Clinic at Stanford Law School. Pam's scholarship focuses on constitutional litigation, particularly with respect to regulation of the political process and anti-discrimination law. And finally, we have Lindbergh Porter, who is sitting to Pam's left. Lindbergh is a shareholder emeritus and former chairperson of Littler Mendelssohn's board of directors. Since his retirement, he has been a voter participation activist, volunteering with voter education projects, get out the vote efforts, and political campaigns in several states. In recent elections, he has served as a poll watcher or representative for state Democratic parties in several southern states, including Alabama and Georgia. He is now a resident of Holmes County, Mississippi, where he lived in 1965 when the Voting Rights Act was signed into law. To our panelists, thank you for taking time out of your busy schedules to be part of this important and very topical program. Now it is my honor to turn things over to Judge Lynn.
Thank you, Kathleen. I also want to thank Kathleen for the extraordinary efforts that she took to find us a new venue at the last moment for this panel. When we couldn't hold it in the ceremonial courtroom because it got shut down. So thank you for all the hard work. I'm so excited to be with our panelists here today, many of whom have firsthand experience with both the litigation involved in the early days of the Voting Rights Act and through our current times, as well as with the passage of the Voting Rights Act. We're going to present this panel in 3 phases. The first part, we're going to talk about the reasons motivating the passage of the Voting Rights Act in 1965 and some of the challenges to voting that were present at that time. As well as the political process that led to the passage of the act. Then we're going to move more into the 70s and 80s and talk about the immediate impact of the act and some of the litigation in that time frame. And then we're going to move in the last phase to 2010 to the present, talking about some of the new developments in terms of the Voting Rights Act and the litigation more recently, as well as the litigation that's pending before the Supreme Court now. So let's start with the Voting Rights Act in 1965. I'm just going to ask Lindbergh to set the stage for us and tell us about the challenges to voting in that time period and what was motivating the passage of the act.
Thank you, Judge Lynn, and good evening. It's still afternoon. Good afternoon to everybody. It's good to be here. Yesterday in Holmes County, Mississippi, where I'm from, I attended a regularly scheduled meeting with a person who earlier this year was a coordinator for a committee that attempted to recruit me to run for mayor of Lexington, Mississippi, the county seat of Holmes County, where I grew up. That person is the current generation of the relative of the county clerk and registrar of voters who in 1950 and 1960s absolutely prevented my grandfather from voting, telling him that the Constitution of the United States did not apply to him, and that even if it did, he was not qualified to vote. My grandfather was the principal of a Black segregated high school in Holmes County. He held a master's degree. The registrar said the same thing to everyone else who attempted to vote in Holmes County or dared to show up at the courthouse before 1965. And indeed, as of 1965, of 18,000 eligible Black voters in the county, not a single one was registered to vote. President Lyndon Johnson delivered a dramatic speech on March 15, 1965, 1 week after the Selma March in Alabama. He challenged the Congress to enact the federal legislation that would guarantee the voting rights and prohibit various tests and devices that had been used to prevent Black folk from voting, including my grandfather and those like him. Johnson said, and I quote, "The harsh fact is that many places in this country, men and women are kept from voting simply because they are Negroes. Every device of which human ingenuity is capable has been used to deny this right. The Negro citizen may go to register only to be told that he's there on the wrong day, or that the hour is late, or that the official in charge is absent, and that if he persists and manages to present himself to the registrar, he may be disqualified because he did not spell out his middle name fully, or because he abbreviated a word in the application. And if he manages to fill out an application, he is given a test. The registrar is the sole judge of whether he passes the test. He may be asked to recite the entire Constitution or explain the most complex provisions of state law. And even a college graduate cannot be assured that he will pass because he is questioned about whether he can read or write. For the fact is that the only way to pass these barriers is to show white skin. No law that we now have on the books can ensure the right to vote when officials who determine the right to vote deny it. That was the experience of my grandfather as I started today. And so we have the background of the Voting Rights Act and the reason for it, particularly as practiced in the southern states. The day after Lyndon Johnson made that speech to Congress, or 2 days after, the legislation was introduced in the House and of course in the Senate, and there were hearings on it, and the debate ensued. On the first day of debate, Mississippi Senator James O. Eastland, one of the biggest landowners in Mississippi Delta at the time, said This bill flies directly in the face of the Constitution of the United States. Let me make myself clear. I am opposed to every word and every line in this bill. I believe that it is an unheard of thing. This bill would apply only to 5 states. It's sectional legislation, it's regional legislation, and it should not go further. Senator Dirksen of Illinois in the Senate responded, "We could be prepared to come to this chamber with thousands of cases and show that it is precisely what has happened. It is almost astounding, the ruses, the devices, the schemes which were employed to deny people the right to vote after the passage of the 15th Amendment 95 years ago. This is in 1965. And so that's the background that we started with. In 1965, as I mentioned, in Holmes County, Mississippi, and I talk about Mississippi, I could talk about Georgia, Alabama, Texas, Louisiana, would be the same. As I mentioned, in 1965, immediately after the Voting Rights Act passed, 10 folk were registered to vote in the face of violence and so on. In Holmes County, the last of the lynchings occurred in the 1950s. Some 10 people were lynched during that period, some of them for attempting to vote. In 1967, the number of registered Black voters after the passage of the Voting Rights Act had gone from 0 to tens of thousands, high enough in 1967 to elect the first Black legislator to the Mississippi House of Representatives since Reconstruction, Robert G. Clark. Clark served until 1976 as the sole Black member of the Mississippi legislature. In that time, however, he shepherded and insisted and agitated for and built coalitions to pass the Education Reform Act in Mississippi, which started the first K-12 to kindergarten program in Mississippi, and urged the passage of the Medicaid Expansion Act after it had become national law. And today in Holmes County, as I mentioned, the relative of the person who denied my grandfather the right to vote is recruiting Black folk to run for office. I'm going to come back to that at the end, but I wanted to paint you the picture from the ground, and let me end with this. That was important, but what was more important to me, when I was 14, I had not read the Constitution of the United States, wasn't taught in schools. I had not read the 14th or 15th Amendment. The 13th Amendment I knew about, but I knew it in the context of Abraham Lincoln having, quote, freed the slaves, and that's all. That's all was taught, all was permitted to be taught. I read for the first time, accidentally, the 15th Amendment of the Constitution of the United States, that the right to vote should not be denied on the basis of race or color or previous conditions of servitude. And I had not seen or read that before or heard it. And I went running home to my parents, and I said, all of the marching, all of the violence, all of the threats that we are undergoing and living with here, we don't have to do that. Says right here, the 15th Amendment gives us the right to vote. And my parents said to me, that's not the way it is. And I can't tell you the loss of faith I saw in my mother and father's faith having to tell me that. Two people that I thought were the greatest, most competent, effective people in the world. And to disappoint a teenager of 14 was heartbreaking for them. And then when the Voting Rights Act passed, suddenly there was a strength, a determination, and a renewal of that dignity that they always had. And that, to the extent that it has transformed the South, the Voting Rights Act. And the respect that children have for parents and the respect that parents have for themselves. That's the real story and its effect on the southern states of the United States. And we've had other effects, and we're going to hear about those. But I want you to know that it's grounded in the reality that changes and that transforms lives of people on the ground.
I want to ask Lindbergh and the other panelists to comment on, in the immediate aftermath of the passage of the act. I know there is this kind of sea change in the way people are signing up to vote. What are some of the other impacts that resulted just in the few years right after the act was passed?
Well, as I mentioned, the example that I used was Robert G. Clark, having been elected first time in Mississippi. Other states, same thing. Georgia, less so, because Georgia was less hostile than had Mississippi been until that time. And so the number of legislators and office holders across the South increased dramatically immediately after 1967 and 68. They were not always seated. It reminds me of this case in Arizona now, where the Speaker of the House refuses to seat the elected congressperson. Same thing happened with Robert Clark in the Mississippi State Legislature. The legislature the Speaker of the House refuses to seat him, and it took a while. But that is the most immediate impact, the election of Black officials throughout the South, such that now, of course, the South has more Black elected officials per capita than any other state. So those folks made a difference. I use the example of Clark and Education Act and the Medicaid expansion and others, and that was similar in other states.
So just a couple of things, and it's such a pleasure to be here. I just want to lay a little bit of foundation for the different provisions of the Voting Rights Act and what they actually did. So Lindbergh was talking about how people got registered to vote. And a lot of that was because the original Voting Rights Act in 1965 had a provision in it that provided for federal registrars and examiners to go south and put people on the voting rolls. And so civil servants were sent south from various parts of the government to register people. And as a result, more Black voters were registered between 1965 and 1967 than had registered since 1900. So one thing that the Voting Rights Act did, because there was the political will to do this, was actually get people onto the voting rolls. The second thing that the Voting Rights Act did that was really important in the South, particularly in the period between 1965 and the mid-1990s, was there was a provision that not only suspended the use of literacy tests in the South. And originally it suspended them only in parts of the South and only for 5 years. But in 1970, Congress made the ban on literacy tests nationwide. And in 1975, it made it a permanent nationwide ban on literacy tests, which were the major device that was used to keep people off the voting rolls in the way that Lindbergh was talking about. But the other thing that the act did was it said, okay, we have managed to stop you from using these literacy tests, but we know what happened in the past is every time a court enjoined some practice that made it harder to vote, they'd just come up with another one, and it was like whack-a-mole. And so the act also had this provision in it that said, with regard to these southern states that had had a history of literacy tests and low political participation, that if they made any change, no matter how small, in their voting laws, they would have to get federal approval before that change could go into effect. And they would have to show to either the Department of Justice in Washington or to a federal district court in Washington, not a local district court, that the change would have neither a racially discriminatory purpose nor a racially discriminatory effect. And so the way the Supreme Court kind of talked about this was that it shifted the burden of time and inertia from the victims of discrimination to the perpetrators. And this was especially important because in Mississippi, by 1970, the state moved from having elections by district for county commissions to try and do them at large, which would mean that even if Black voters were registered, they wouldn't be able to elect a candidate of their choice. They made some positions appointive rather than elective, like the superintendent of schools in each county, which meant that even in majority Black counties, the person would be appointed by the governor rather than elected by localities. And the Supreme Court took a really strong view of what it meant to say there was a change that affected voting. It didn't have to be about voting. It could be things like a rule in Georgia that you couldn't run as a candidate for any office if you were a school employee, which of course was tremendously difficult in the South because a huge part of the most civically minded, most politically savvy folks were school teachers. And if they couldn't run, there wasn't somebody else who could. And so the pre-clearance provisions, as they came to be known, were what really created the effectiveness for the Voting Rights Act, because otherwise a lot of these jurisdictions would have just come up with something else to do if they couldn't have literacy tests to bar people from voting altogether. And so that, I think, was, you know, the real contribution of the Voting Rights Act was to get people onto the rolls and then to say, you can't change your election laws to come up with some other way, not just of denying people the right to vote, but also diluting the voting strength of the new Black voting communities. So you couldn't adopt things that made it harder for that community to elect candidates of its choice. And just one last piece of this, which is, I think is worth understanding, is that the Voting Rights Act then expanded to cover a number of other groups in the United States that had been traditionally disempowered through what are called the language minority provisions of the Act. And these apply to protect Latinos, to protect Asian Americans, and to protect Native Americans and Alaskan Natives. You know, the South, as Lindbergh said, the South, there was this huge revolution. But as late as the 1990s, you still had parts of the country, and we'll return to this later, particularly Indian country in the Trans Mountain West, where Indian communities were completely disempowered. And the Voting Rights Act has been used there as well to deal with disenfranchisement and dilution.
It's such an honor to be a part of this panel. Judge Lynn, my answer to your question is that the Voting Rights Act had a dramatic, rapid effect in increasing registration of Black voters. It had an effect of leading to more Black individuals being elected to political office than at any time since Reconstruction, and undoubtedly made a difference in terms of legislation that was passed. Lindbergh talks about the 15th Amendment that was adopted in 1870. It had an immediate effect. There was an effect throughout the country in terms, and including in the South, of registering Black individuals and Black individuals being elected to public office. But all of that ends when Reconstruction ends. And immediately after Reconstruction, Southern states adopt a variety of different ways of disenfranchising Black individuals from voting. We've talked about things like literacy tests and the accompanying grandfather clause. There were poll taxes that existed until the early 1960s, the white primaries that developed throughout the South. And there was just the intimidation and violence and force used to keep Black individuals from voting. In 1940, in the states that comprised the Confederacy, only 4% of Black individuals were registered to vote. And it hadn't gotten much better in some places, even in the 1960s. Talk about Mississippi. In 1964, only 6.7% of Black individuals in Mississippi who were otherwise eligible to vote were registered to vote. And that's compared to about 70% of white individuals in Mississippi. In Alabama in 1964, only 19% of Black individuals eligible to vote were registered to vote. This is where the 1965 Voting Rights Act matters so much. A year later, in 1966, in the states that comprised the old Confederacy, in 9 out of 13, more than 50% of Black individuals were registered to vote. And that's so dramatic just in the context of a year, see the things that are going on in terms of federal registration to vote, but also the effects of eliminating literacy tests, eliminating poll taxes, finally eliminating white primaries, and slowly eliminating the intimidation and violence that occurred.
Let's look at one point. Before Reconstruction in Mississippi, after the passage of the 1870, the 15th Amendment, there were 104 Black legislators in the Mississippi legislature. In 1880, there was 0 and continued to be 0 for another 95 years.
Let's move to talking a little bit about the litigation in the early years, in the maybe the 70s and early 80s. I'll just invite the panelists. I'll open up to any of you who are interested in talking about this. But will you tell us about what the focus of the early litigation was in that frame?
So a lot of the litigation was actually about what needed to be pre-cleared. In the mid 1970s, the Supreme Court held that you had to pre-clear any redistricting, which turned out to be really important. So you couldn't draw districts that made it impossible for the Black community to elect candidates of its choice. And that was super important. There was litigation. So most of the Voting Rights Act litigation was actually Section 5 litigation at that point, because Section 2 of the Voting Rights Act, which we're going to talk about a lot, I think, going forward, just restated the 15th Amendment in its original form. And then in 1976, in a case, maybe I should get to 1980 and say, in 1980, in the Supreme Court's decision in the City of Mobile against Bolden case, what the Supreme Court said is, if you wanted to challenge a practice that diluted minority voting strength, that is, that didn't deny it, but just diluted it, you would have to show that the practice had been adopted or maintained for a racially discriminatory purpose. It wasn't enough to show that it had that effect. And so Congress then amended the Voting Rights Act in 1982, both to extend preclearance for another period of years, and also to create what came to be known as the results test, which is, it doesn't matter why you have this districting system or why you have runoff primaries, which is what I spent a bunch of time litigating in Arkansas in the 1980s. It doesn't matter why you adopt this, as long as it has the effect, as long as it has the result of denying minority voters an equal opportunity to elect candidates of their choice, you can't use this. And so the 1982 amendments to the Voting Rights Act created a whole new wave of voting rights litigation that challenged practices on the grounds that they had a dilutive effect, regardless of why they were adopted. And you saw a huge range of cases, because the Supreme Court in the Thornburg against Jingles case, which was a case about North Carolina and elections for the North Carolina General Assembly, came up with a test that was a real green light to litigators to bring cases all over the country. And so just talking about two cases that I worked on, one of them, I think maybe one of the few times that a judge has ever certified a 23B2 defendant class of 190 jurisdictions in Alabama that had large numbers of Black citizens living in them and that were using at-large elections. And so we managed, rather than suing each individual jurisdiction and showing that that jurisdiction had a plan that was diluting minority voting strength, what the judge said is, I find that all of these were adopted with a racially discriminatory purpose, in the sense that that was what led Alabama to go back and forth between at-large and districted elections over the period between about 1875 and 1950. And with that commonality of a finding that all of these might be tainted by their initial purpose, we just rolled up the state, and ultimately about 170 of these jurisdictions settled. And they adopted, for the most part, districting plans that allowed for the creation of majority Black districts from which Black voters could elect people to city school boards, county school boards, city councils, and county commissions. And some of the jurisdictions actually adopted alternative voting systems that had not been used anywhere in the United States, or had been used only very infrequently, like limited voting or cumulative voting, which is kind of like the way you vote in corporations, like one share, one vote. This was, each voter got 5 votes, but you could cast all 5 votes for the same candidate if you wanted. And that enabled a minority community, even if it didn't live close together, to pool its votes and elect candidates. And so, you know, there was an opportunity to do very innovative stuff there. And then the other case that I did that's a kind of interesting case is, you know, it's not just legislators where it matters, it also matters who the judges are. And we brought voting rights cases in Louisiana, in Alabama, and in Mississippi to challenge the way judges were elected, because these are all states that elect judges in partisan elections. And we changed the way that they elected the judges in ways that produced the first Black judges on the bench in those states, because there were now, you know, if you had a bunch of majority Black counties in a particular judicial circuit in Mississippi, there would be an opportunity for the Black community to elect judges of its choice.
And they have.
Yeah, yeah.
In the Mississippi Delta on the Court of
Yeah,
Appeals,
yeah.
the two judges, and they're both black, so.
Yeah, and there are Black judges now in every one of the southern states, which was not something that you had prior to this. And so it was an opportunity to do very innovative kinds of litigation in the period really between about 1986 and 1994 or so. And then the law changed a bit because the Supreme Court decided a case called Shaw against Reno, which said that you sort of had to run this Goldilocks line, which is you had to take race into account to comply with the Voting Rights Act, but you couldn't take it into account too much, because if you took it into account too much, then you would be violating the Equal Protection Clause of the Constitution. And it's part of the Supreme Court's move towards the idea that the 14th Amendment requires a particular kind of color blindness.
We just invite the other panelists to talk about some of the early litigation and then maybe also the passage. We talked a little bit about the passage of Section 2, the amendment to Section 2 after the Mobile v. Bolton case. But I think it'd be interesting to hear about how that happened, what the politics of that were.
Pam's description is terrific. I would just add a couple of things. One is the Voting Rights Act didn't stop being controversial when it passed Congress. It was enormously controversial at the time, and there were immediate constitutional challenges brought to it. And the states were arguing that this is an intrusion onto state sovereignty. The argument was that requiring pre-clearance of some states and not others was inappropriate. The argument was that the burden that was put on the state to have to get pre-clearance was impermissible as an infringement of state sovereignty. And what's so dramatic is the Supreme Court time and again keeps upholding these requirements in the face of the arguments until we get to, and we'll talk about, Shelby County versus Holder in 2013, where the court then strikes it down. But the pre-clearance had expirations, and each time it was about to expire, Congress renews it. Each time it's renewed, it's challenged again in the Supreme Court, and each time it's again upheld by the Supreme Court. The other thing I just want to put into part of the discussion of what was going on at the time, at the same time the Voting Rights Act gets adopted, the Supreme Court is enforcing the requirement for one person, one vote. Earl Warren, after he finished being Chief Justice, was asked what was the most important case decided during his tenure. And he said it was Baker versus Carr and Reynolds versus Sims, the one person, one vote, because situation where the political process wasn't going to fix itself. Many states were badly malapportioned, and the legislators who benefited from malapportionment weren't going to voluntarily engage in redistricting. The way in which this also relates to what we're talking about is in urban areas, let's say Chicago, where I grew up, there was a vast underrepresentation because the southern part of the state was overrepresented because of malapportionment. The effect of one person, one vote was to shift much more voting strength to urban areas compared to rural areas in states that had both. You tie this with the enforcement of voting rights, and you really see an enormous effect. In answer to your specific question, Judge Lynn, as Pam says, City of Mobile versus Bolden was a serious blow to Section 2 of the Voting Rights Act. As we'll talk about later tonight when we discuss the case that's before the Supreme Court now, Louisiana versus Calais, it's enormously difficult to prove discriminatory intent. In fact, it's become much more difficult over time as legislators are less likely to openly express racist purposes. Also, we know so much more now about implicit bias and unconscious racism. So if you require proof of discriminatory intent, it's going to be very difficult to show a violation of Section 2. And Congress then, 2 years after City Mobile versus Bolden, amend the voting rights. City Mobile versus Bolden involved Mobile, Alabama. It had a 3-person city council. It might have drawn the city into 3 districts, but it didn't. It had an at-large election where every voter cast 3 votes for the 3-person city council. Mobile at the time was 2/3 white individuals and 1/3 Black individuals. It had a long history of racially polarized voting. The result was that no Black individual had been elected to the Mobile City Council in the 20th century. And the challenge was brought saying that this violates the 14th and 15th Amendments. And the Supreme Court rejected it, saying, unless it could be proven that the creation of the at-large election was motivated by discriminatory purpose. It didn't violate the Constitution. That caused Congress to then adopt the 1982 amendments to say that, like it is for employment under Title VII, or like it is for housing under the 1968 for Housing Act, proof of a racially discriminatory impact was sufficient for liability. As I say, that's what's right now being challenged in the Supreme Court in Louisiana versus Clay.
Can I just add one thing here, which I think is important about the passage in 1982 of the amendments, and then in 1997 and 2007, the additional extension, which is these were done in a completely bipartisan way. That is, voting rights was not a partisan issue in 1982. In fact, one of the most striking things is that Congress decided to hold a bunch of hearings around the country, and they went down to Alabama to hold hearings. And Henry Hyde, who some of you may remember as the proponent of the Hyde Amendment, which restricted federal funds for abortion, and who was quite conservative, was so shocked by what he heard in Alabama about the continued resistance of Alabama to Black voting rights that he became a major sponsor of the Voting Rights Act. And the provision, the results provision in Section 2 of the Voting Rights Act was in large part crafted by Senator Robert Dole, who was a conservative Republican from Kansas, and you may remember was a candidate ultimately for president. So it was totally bipartisan. And then in 2006, when the Voting Rights Act was last extended, the vote in Congress was 98-0 to extend the act. And I still remember at the oral argument in the Namudno case, which was a challenge to this, Justice Scalia said, what was the vote in Congress? And Debo Adegbile, who was arguing, said it was 98-0. And Justice Scalia said, well, that's kind of suspicious. If Congress passes something 98-0, I mean, isn't that a sign that they didn't think about this very much? And and the devil got my tongue. But when I was writing the forward to the Harvard Law Review about the session, I pointed out that he was confirmed 98-0. And so, if this is a suspicious vote, there's more than one time. But it really was not. It was not a partisan issue. And I think it's important to remember that, because right now voting and whether to ease voting restrictions or make them more restrictive seems to be highly partisan, but that was not how this was in the period between 1965 and 2006.
I don't disagree with anything I've heard.
Let's move into the 2010 and later era. And I just want to ask Erwin and Pam to talk a little bit more about some of the cases that they worked on during that time period, kind of leading up to Shelby County.
You want to start?
Sure.
No, go ahead.
I'm talking about cases a little bit from the earlier period, but I think they very much illustrate the point that you were making and asking your questions of how much changing who votes changes who's elected, and changing who's elected then changes the results of what you get through the legislative process. I was involved in a couple of cases in Los Angeles. I was a professor at USC at the time. One was Garza versus County of Los Angeles. The Los Angeles County Board of Supervisors had for a very long time just 5 members. And think of how large Los Angeles County is. And it had never historically had a Latino representative. And Malda and the ACLU brought a lawsuit challenging this, and they did so under Section 2 of the Voting Rights Act. And they claimed both that there was intentional discrimination and that there was a discriminatory impact. When you think of the percentage of Los Angeles County that was Latino and never having a Latino representative. And the reality for the Los Angeles County Board of Supervisors, like so many legislative bodies, is they engaged in districting to protect the seats of incumbents. There were no term limits for the members of the Los Angeles County Board of Supervisors. So the most important thing that they focused on in drawing districts was making sure that they would keep getting reelected. And that wasn't going to change voluntarily. Again, as I was saying with regard to male apportionment, they weren't going to draw districts to take themselves out of office, and tremendously powerful offices. There's no mayor for the county of Los Angeles. It's the 5 supervisors. And I was able to work with the ACLU on the lawsuit. and one in the district court, and then one 2-1 in the Ninth Circuit, an opinion by Judge Mary Schroeder. And she affirmed a finding of both intentional discrimination, but also discriminatory impact. That immediately led to new elections and new districts. It led to the election of the first Latino representative on the Board of Supervisors, and it's been so ever since. And I think it's made a real difference in terms of outcome. The other case had a much more direct role in, and it's interesting with regard to how when you talk about voting rights, especially voting rights for minority groups, how sometimes there can be a tension among those groups. And this was a lawsuit that was filed against the city of Los Angeles. Los Angeles has 15 city council districts for a very large city. Compare that to Chicago with 50 council districts, New York with 51. There are only 15. And again, it was a situation where Latino voters were substantially underrepresented relative to their population. And the concern was the way they would create additional Latino districts was to decrease the number of majority Black districts. And so I was asked to represent the NAACP in the litigation and intervened on behalf of the NAACP. And the main goal of the intervention was to make sure that the NAACP would have a seat at the table when the districts were drawn, so that increasing representation for one minority group didn't come at the expense of another minority group. And in fact, that case did settle, and it preserved the 3 council districts that were majority Black while creating an additional majority Latino district. And again, I think I can show you, having lived in Los Angeles at the time, that when there was increased representation of people of color, it really did translate into different policies on the part of the city of Los Angeles.
So this goes back to what I was saying earlier about the partisan, nonpartisan nature of this, which is after the Voting Rights Act was extended again in 2006 so it was going to run until 2031 that you would have to get pre-clearance. There were challenges brought to this, and the first of these challenges was known as NMUDNO, Northwest Austin Municipal Utility District Number 1. That's why it's called NMUDNO, against Holder, which was a challenge to whether you could continue to require pre-clearance in these jurisdictions when the formula for deciding who had to get pre-clearance was a formula that looked at elections in 1964, 1968, and 1972. And in NMUDNO, I represented the bipartisan leadership of the House Judiciary Committee, which at the time, trying to remember right, because I represented them twice. I represented them both in NMUDNO and in Shelby County. And one time the Republicans had control of the House, and the other time the Democrats had control of the House. But both times, the leadership of the House Judiciary Subcommittee on civil and constitutional rights wanted to support the Voting Rights Act. So one time it was Jim Sensenbrenner from Wisconsin who was spearheading this, and the other time it was Jerry Nadler from New York who was spearheading this. And the arguments that we made were that the Voting Rights Act lies at the kind of intersection of protecting a fundamental constitutional right, the right to vote, and preventing racial discrimination. And these two things are where Congress's power should be at its apogee. And in NMUDNO, the Supreme Court dodged the issue and essentially left open the question whether the act would be constitutional. The problem was that it's very hard to draw a new formula. And the reason it's hard to draw a new formula, if you think about it, is a little bit like the problem of people with high blood pressure, which is if you've got high blood pressure and you're on high blood pressure medication, your blood pressure goes down. Right? So if you look at the person now, you say, well, this person doesn't have high blood pressure, so we can take them off the medication. But if you take them off the medication, their blood pressure will spike. And the problem that we had, which the Supreme Court didn't seem really to understand or be willing to acknowledge in Shelby County, was these jurisdictions in the South, if you didn't see continued discrimination, they said, well, then you don't need the act. But of course, it's the act that's preventing the continued discrimination. If you did see the discrimination, then you'd say the act doesn't work, so you don't need the act. So it was a kind of heads you lose, tails we win. And literally the day after the Supreme Court decided the Shelby County case, which was the case where they said that the pre-clearance formula was no longer valid, and therefore everybody in the United States was taken out from under pre-clearance. Literally the day after, the Speaker of the North Carolina General Assembly said, let's go forward with the big bill. And they adopted a bill that got rid of pre-registration of 16 and 17-year-olds, cut back on the number of days of Sunday voting, which is really important in the South because of the Souls to the Polls movement, which is people go to church and then the church organizes a caravan to transport people to the polls to vote, got rid of same-day voter registration. And for those of us in California, all of this looks really weird because in California, we've made it extraordinarily easy to register. The state sends everybody a ballot. You can, I just got my thing from the Santa Clara County Registrar saying, if you're not registered, come in, you can register and cast your ballot right here, right now. So it seems really odd, but North Carolina adopted this bill, which ultimately the Fourth Circuit said picked the ways that Black voters were registering and voting with almost surgical precision. That's the language from the Fourth Circuit. Pick those out. Texas came up with a new voter ID bill the day after the Voting Rights Act was right after the Shelby County decision. And that new way of requiring voter ID was ostensibly designed as an anti-fraud measure. But of course, the vote fraud that occurs in the country, and it's not that there's zero vote fraud, there's some vote fraud. It's not committed by individual voters showing up at the polls and pretending to be people they're not. Because if you think about it, the incentive for an individual to show up to vote illegally is really low, right? What's your chance of having a decisive effect on the outcome? Not very much. What's your chance of being arrested? Non-negligible. And so what vote fraud there is not committed by people pretending to be some other voter at the polls. I worked on the Indiana case about this, and in discovery, the state was asked how many examples of in-person voter impersonation fraud do we have in the history of Indiana, which goes back to like the 1830s, and they couldn't point to a single example. They did point to Boss Tweed in New York doing this in the 1870s, but that seems a little far afield. So, so Texas adopted this law, and think about what they did. They said you had to have a currently valid photographic issued by the state of Texas identification in order to cast your ballot. And there were something like 500,000 voters in Texas registered to vote who didn't have this kind of identification because old people often let their driver's licenses lapse because they're not driving anymore. Young people in urban areas often don't have driver's licenses. And they said you can't use a city ID. That is, if you're a municipal employee, you can't use your municipal ID card to vote. That's not good enough. You can't use a University of Texas ID card that's given to you as a student, but you can use your concealed carry permit. Right? So they picked which things you could use and which not, based essentially on who was going to be able to vote. That law ultimately got struck down as well. But instead of having Section 5, which would have kept that law from going into effect at all, it took hundreds of hours, thousands of hours of government time, because the Department of Justice sued over this, and thousands of hours of private lawyer time to bring a lawsuit and get this stuff stopped.
Can I just add one thing quickly?
Yes, and then I want to also hear from Lindbergh about.
Oh, Lynn, go ahead.
No, I was just gonna talk the practical effect of that, and the of thwarting it or dealing with it. And one of them in Mississippi, in particular in the Delta, which is 60, 70, 80% Black, and certain areas in Alabama, Georgia as well, where there are high percentages of Black elected officials and election commissioners who are responsible for enforcing these rules or not enforcing them, or enforcing them in ways that would make it fair. You see the results of that because people know one another, and the initial call about whether someone should vote goes to somebody in the county and then somebody in the state. And in small communities, everybody knows everybody. And historically in Mississippi and rural areas, women didn't vote, women didn't have driver's license that much because of misogyny and 1,000 other things that are not peculiar to Southern culture, but certainly endemic in Southern culture. Didn't have IDs, but everybody knew them. And so allowing someone to vote was dependent on who the election commissioner was, or who was the representative at the polling place, and the extent to which that person would go to verify that this person is who the person appearing is the person who's entitled or eligible to vote. And so that occurred, and it still does occur. So who is elected and who is appointed makes a difference in the practical effect of some of these impediments or efforts at impeding voters.
I just wanted to add, Pam talks powerfully about the importance of preclearance and discusses what happens when preclearance ends. What I only we've mentioned is what was the reasoning in the Shelby County decision? And it was a 5-4 decision, and Chief Justice Roberts wrote it. And always when I teach it, I ask my students, what constitutional provision or principle did the Supreme Court find that the preclearance requirement failed? The court found that the formula was in the Voting Rights Act was impermissible, that Congress had not updated the data. Because Congress doesn't have a requirement for documenting a need for a law. So it can't be unconstitutional just because they didn't update the data. And the answer is, Chief Justice Roberts, writing for the majority, said that there's a principle of equal state sovereignty, that Congress has to treat all states the same. And preclearance was only being imposed at that point under the formula 9 states and on local governments all over the country. And of course, I always say to my students, and where in the Constitution do you find a requirement that Congress has to treat all states the same? For those who are originalist justices, certainly not in the text of the Constitution, but it also can't be supported by the history of the 14th and 15th Amendments. The same Congress that ratified the 14th Amendment passed the Reconstruction Act, which created military rule over the southern states. And so Justice Ginsburg, in one of her famous iconic dissents, makes just a point to Tampa, say, this is just like saying, well, I've got an umbrella and I'm not getting wet, so I can throw away the umbrella. And I mean, immediately after Shelby County, as Pam says, southern states put into effect the very things, Texas, North Carolina, that preclearance have been denied for. And Justice Kagan, in a dissenting opinion in 2020, pointed to the statistics that between 1965 and Shelby County, every year there was always an increase in registration among Black voters. That after Shelby County, for the first time since 1965, registration among Black voters went down. So denying the provisions with regard to preclearance had an immediate and long-term effect.
Let's also just talk generally a little bit about the private right of action cases. I think it'd be helpful to hear from Pam about where those are at.
Sure. So there are 2 ways essentially that the Voting Rights Act gets enforced or has been enforced historically. One is by the United States Department of Justice, which was always the defendant in Section 5 preclearance actions. That is, you had to either go to the Department of Justice or sue the United States to get preclearance. And the United States brought a number of voting rights lawsuits. And, you know, the resources that the Department of Justice has for this, while not unlimited, were probably larger than the resources of any other entity that brought voting rights lawsuits. I mean, there were more lawyers in the voting section of the Department of Justice than there were lawyers at the NAACP Legal Defense Fund or the ACLU who specialized in voting rights. But most voting rights lawsuits were brought on behalf of the individual voters in a particular county. And these were brought by private lawyers. And starting in 1969, the Supreme Court held repeatedly, first held that there was a private right of action under Section 5 of the Voting Rights Act to force a state or a local jurisdiction to get preclearance before making a change. And then in a case I argued in 2007, I think it was decided by the Supreme Court, they held that the poll tax provision in the Voting Rights Act gave rise to a private right of action. That is, you could challenge a poll tax. In that case, it actually was a law student who raised his hand in my voting rights class and said he wanted to go to the Republican nominating convention in Virginia. This was in 1994 to support Jim Miller, who was running against Oliver North for the Republican nomination for US Senate. And they told him he had to pay $45 to go to the convention. And I told him, they can't do that. And he said, well, they're doing it. And I said, let's talk after class. And so he came into my office after class and he said, you know, they're going to charge me $45. I said, they can't do that. Here's a list of cases. Go down there and tell them they have to let you vote for free. And he came back about an hour later and he said, I went down there and they told me I have to pay the $45, but if I support Oliver North, his campaign pays the $45 for me. And I said, I advise you not to take the $45. And he said, why? I said, well, because I'm not exactly sure, but I think it may violate 18 USC 497, I think it was, which is the vote buying provision. And I wasn't sure whether it did or not, but I thought bad idea. And he said, well, what else could I do? Could I sue over this? And I said, sure. And he said, will you be my lawyer? And I wasn't admitted in Virginia, so I went to the office of the guy whose office was next to me. I said, will you be local counsel? And we filed a lawsuit. And by the time he was a third-year law student, it was up at the Supreme Court. Yes, Virginia had to get pre-clearance before charging the $45 because they hadn't charged people in 1964. And the poll tax provision in the Voting Rights Act gave rise to a private cause of action. So Section 5 and Section 10 of the Voting Rights Act, the Supreme Court held, had private rights of action in them. And then with regard to Section 2, the Supreme Court has decided, I don't know, 40 Section 2 cases over the last 30 years. And in almost every one of them, it was a private party who brought the lawsuit. I think there may be 2 where the United States brought the lawsuit. So pretty clear. But about 5 years ago, a district judge in Arkansas held that there was no private right of action, implied right of action under the Voting Rights Act for individual voters to bring a lawsuit. And then a district judge in North Dakota said that there was a private right of action. And these cases went up to the 8th Circuit, which is probably the most conservative circuit in the country in the sense that there's only one person who's nominated by a Democratic president on the entire 8th Circuit. And first they held that there's no implied private right of action under the Voting Rights Act. And for those of you who follow the kind of implied right of action stuff, you know that the Supreme Court has become increasingly skeptical about implied rights of action. And when I was at DOJ, one of the things I said when we were filing some briefs saying, yes, of course, there's an implied right of action, was, you know, we could also rely on Section 1983 here, which gives an express cause of action for deprivation of rights secured by the Constitution and laws of the United States. And the Supreme Court has said when you have a rights creating statute and the right is you're deprived of the right by somebody acting under color of law, you can use Section 1983, which means in its express cause of action. And I said, so let's not worry too much whether there's an implied right of action because there's an express one. So then in North Dakota, they had a challenge by the Turtle Band of Chippewa Indians to the way that North Dakota was setting up state legislative districts. And they said, you're diluting the votes of Indian voters in the way that you drew the districts. And the district judge held a whole trial, said, yes, this violates Section 2 of the Voting Rights Act, went up to the 8th Circuit, and the 8th Circuit said, oh, not only is there not an implied right of action under the Voting Rights Act, there's no express right of action under Section 1983 because, I kid you not, the Voting Rights Act is not a rights creating statute. I know. It's, you're saying to yourself, but it's called the Voting Rights Act. And it says no state shall deny the right to vote. But that's not enough for the 8th Circuit. So the case is now up at the Supreme Court. The Turtle Band has petitioned for certiorari on, yeah, we've got a cause of action. The Supreme Court stayed the mandate of the 8th Circuit. So at least for the next couple of months, they still have to use the new districts, which give the Turtle Band the ability to elect somebody to the state legislature. But a couple of days ago, the Supreme Court rescheduled whether they're going to consider whether to hear the Turtle Band case. So it looks like they're postponing deciding whether they're going to take the case, which there's a clear conflict in the circuits because every other circuit has allowed people to bring cases, individual voters to bring cases. So I don't know what's going to happen with that. I mean, I find it hard to believe actually that the Supreme Court is really going to say with a straight face, there's no private right of action under the Voting Rights Act. We just adjudicated these cases for the last 50 years in total error. I just think
I would maybe be less surprised if the Supreme Court did. 98% of the cases on the Voting Rights Act were brought to history by private actors, by private individuals and organizations. And there's a case pending now brought by the Mississippi Attorney General, the State Board of Election Commissioners versus NAACP, a group of direct challenge to Section 2, and the state is arguing that there is no private right of action under Section 2, that the enforcement is reserved only for the Attorney General, and we know what the result of that would be. That private suits undermine the separation of powers and federalism, the split in the circuits, as was mentioned, the Eighth Circuit, the Fifth, and the Sixth. And that warrants review, and that prior precedent, the Allen case, which we discussed, did not settle that issue. And the NAACP and that side of the argument is that the text doesn't say that. It's just that it says rights, civil rights, the right to vote. The Department of Justice does not have exclusive jurisdiction over and as against private individuals or private organizations. Private enforcement enhances and furthers the purpose of the 15th Amendment, the Voting Rights Act, and it's a check and balance. The Eighth Circuit was an anomalous ruling, and finally Allen versus Thornburg and Gingles and Bromwich are all involving private parties, and that's what the Supreme Court has said in the past. So it would seem that the Supreme Court would have a very difficult time doing that. But this is the same Attorney General who brought the abortion case 2 years ago. So it won't surprise me what the United States Supreme Court does in response to the direct challenge to the Voting Rights Action Section 2, leaving us with what then if no private right of action is permitted under the ruling by the Supreme Court.
That's a good segue for us to talk about the Louisiana case that's in front of the Supreme Court now.
Sure.
Lindbergh, Pam talked about, will there be a private right of action still, Section 2? I think ultimately Louisiana Calais is going to ask the question, how much is left of Section 2 of the Voting Rights Act?
Yeah.
Let me tell you the facts, and it was argued October 15th before the court. We can try to read the tea leaves of oral argument. There are 6 congressional districts out of Louisiana. Louisiana's population is about 35% African-American individuals. After the 2020 census, Louisiana, like every state, engaged in redistricting, and they drew the map so there was one majority Black district out of the 6 congressional districts from Louisiana. A 3-judge federal district court found that this violated the Voting Rights Act. If you compare the population of Louisiana versus only 1 out of 6 districts, you see the discriminatory effect we've been talking about. The Louisiana legislature then went back and they drew the districts. So there were 2 out of 6 majority Black districts. A group of plaintiffs who called themselves non-minority voters brought a challenge to this and said that it violated equal protection. As Pam mentioned in Shaw versus Reno in 1993 and Miller versus Johnson in 1995, the Supreme Court said it violates equal protection for race to be a predominant factor in drawing election districts unless the government can meet strict scrutiny. And they said that the Louisiana legislature used race as a predominant factor in creating a second majority Black district. And the 3-judge federal court found that that's right. Louisiana goes to the Supreme Court and says, if we have 1 majority Black voter district, then it violates Section 2 of the Voting Rights Act. When we create 2, it violates equal protection. And the Supreme Court grants review. It has briefing and oral argument last year. I think to everyone's surprise, on June 27th, the Supreme Court doesn't decide the case, but asks for re-argument in this current term. Something occurred that I had never seen before. Justice Thomas writes a dissent from having the case reheard, and he indicates that he believes that Section 2 of the Voting Rights Act is unconstitutional. He says Section 2 of the Voting Rights Act says that discriminatory impact is enough for a violation. That requires that decision makers take race into account. And he says having decision makers take race into account as a predominant factor violates equal protection. And he would have just that day declared Section 2 with regard to disparate impact to be unconstitutional. The Supreme Court, by tradition, decides most cases in the year in which they're argued by the end of June, but there are exceptions where the Supreme Court has asked for cases to be argued the next, often very high profile cases. Brown versus Board of Education was argued in October term 1952, put over for re-argument the next year, and decided on May 17, 1954. Roe versus Wade was argued in October term 1971, put over for re-argument, decided in January 73. Citizens United was initially argued one term, put over. That by itself suggests that this could be momentous. On August 1st, the Supreme Court posed the question that it wanted the new briefing and argument to focus on, and that's whether or not Section 2 is unconstitutional in allowing disparate impact liability and violating equal protection. This is important on so many levels. And it's important in terms of whether Section 2 continues to allow disparate impact liability. In Shelby County, in striking down pre-clearance, Chief Justice Roberts offered the assurance that we still have Section 2 of the Voting Rights Act. But what will Section 2 mean if the court says that you can't have disparate impact liability? Also, if the court invalidates disparate impact liability under the Voting Rights Act as violating equal protection, what will it mean for other civil rights laws? Title VII, for example, ever since 1971 in Griggs versus Duke Power, has allowed for disparate impact liability. In 2009, in Ritchie versus DeStefano, an employment discrimination case, Justice Scalia wrote a concurring opinion in which he essentially said that he believed that disparate impact liability under Title VII was unconstitutional because it requires that decision makers consider race in order to avoid liability. There's disparate impact liability under the 1968 Fair Housing Act. Many state laws allow for disparate impact. So if the Supreme Court were to say that disparate impact liability violates equal protection, it would have a devastating effect on civil rights litigation. I'd be interested in what the other panelists think from the oral argument on October 15th. My conclusion from reading the transcript is that Louisiana, the Supreme Court is going to do real damage to Section 2 of the Voting Rights Act. I just think it's a question what it's going to do. Justice Kavanaugh seemed to want to focus on how much time has gone by and whether or not there's still enough race discrimination in voting to justify needing Section 2 of the Voting Rights Act. He had previously raised that in a concurring opinion in Allen versus Milligan, saying maybe we don't need this anymore. It echoes what Chief Justice Roberts said in Shelby County, but this seems so strange. Why is it for the court to decide whether or not there's sufficient race discrimination voting? And how is the court going to make that decision? What evidence does it have in deciding that threshold? But that's where Kavanaugh was really focused. I think some of the other justices on the Supreme Court were focused much more on does disparate impact liability violate equal protection? So I think that it's going to be 6-3. I think the court's going to do real damage to Section 2 of the Voting Rights Act. Whether it goes so far as to declare disparate impact liability unconstitutional was less clear to me from the oral argument.
I would just say that it seems to me that a question facing Roberts, because I think it might be 5-4. I agree with you with respect to outcome, but 5-4 and how much difference that will make is, I suppose, a different question. But really, at the heart of this, in all the cases that we have talked about in Section 2, it seems that the court is faced with, and Roberts is faced with, whether Roberts is going to preside over a court that effectively, given all of the history and the practical effect of this, resurrects Plessy versus Ferguson in terms of its impact on particularly Black voters in this country and non-white voters as well, whether we will have that circumstance again, because the red states are already acting and prepared to enact and reenact and for the first time in some instances changes that would result in a complete disenfranchisement and of Black voters, and that in turn has an effect on all the other things that we have talked about, resegregation of society and Plessy versus Ferguson again. And I hope that weighs on his conscience.
So absolutely two points that I want to make. One is to pick up on your point about Plessy. And I would say as much as we might point to Plessy, the case that I'm thinking more about is the civil rights cases of 1883, which were the cases that struck down the public accommodation statutes that get reenacted essentially in 1964 as the Civil Rights Act of 1964, and then they get affirmed as proper use of the Commerce Clause power. But in the original cases, the question was whether you could use the 14th Amendment or you could use the 13th Amendment and the badges and incidents of slavery as a way to justify public accommodation statutes. And in the court's decision striking those down, the court says there comes a time when, Black people in the United States should stop being the special favorites of the law and should go back to getting defending themselves in the ordinary way that people defend themselves. But of course, the ordinary way that people defend themselves is through voting and political power. And so if you make it harder for Black voters to exercise their political power, you're not returning them to the ordinary modes of protection. You're taking the ordinary mode of protection away from them. The second point I'll make is an observation about how this ties in with partisanship. Which is quite different, as I was saying earlier, than what you saw in the period, say, 1982 through 2006. And the reason, Louisiana could have drawn 2 majority Black congressional districts that would have looked very normal on the map and wouldn't seem to be districts in which race predominated. And the reason they didn't draw those 2 districts, the reason they drew this very unusually shaped district that goes through the middle of the state, was to protect the seats of the Speaker of the House and Steve Scalise. And they couldn't protect those seats and draw another majority Black district that was very regularly shaped. And indeed, even the first majority Black district in Louisiana was only drawn because there was a lawsuit challenging the failure to draw any. This was a lawsuit called Major against Treen, and I got to work on the attorney's fees part of Major against Treen when I was at the Legal Defense Fund. And one of the things I loved about the attorney's fees litigation there was when the Legal Defense Fund first brought the case, which was while I was still in law school, so I wasn't involved in it. The state moved for Rule 11 sanctions on the grounds that their claim that the failure to draw a majority Black district was so ludicrous that they should be sanctioned under Rule 11. They won the case. And then when they petitioned for attorney's fees, the state came in and said, this was such an obvious example of discrimination that you shouldn't get national rates for the litigation. You should have to get Louisiana rates because any idiot could have won this case, which I think is it's the definition of chutzpah to say first it's sanctionable and then to say, but it's so easy, any idiot could do it. So why does this matter, this partisanship issue? Because part of what the Supreme Court said at the oral argument, several of the justices are suggesting this, is the failure to draw a second majority Black district. You can't ever show that that was intentional because really it was all about politics, not about race. And in parts of the South where race and politics are absolutely aligned, the Supreme Court is now prepared to say, even if you show that they deliberately didn't draw a majority Black district, they're doing that for political reasons, not for racial reasons. Therefore, even under the Constitution, it's perfectly constitutional to do this. And what has happened is the Supreme Court has moved over the last 20 years from its position, last 30 years, from its position in Davis against Bandermer, which is political gerrymandering is constitutionally problematic and justiciable, to its position in Veith against Jubileer, which is we don't know what the standard is for this, but we think it's a problem. All 9 justices thought that political gerrymandering was unconstitutional in Veith against Jubileer. They just couldn't agree on what the standard was. To Rucho against Common Cause in 2019, where they say political gerrymandering is a threat to democracy, but it's non-justiciable. To now, the Supreme Court saying political gerrymandering is a legitimate government interest that rebuts a claim that there's purposeful racial discrimination. And that is a huge, huge change in how we think about what goes on in the redistricting process. And it's going to be, I think I agree with you, Oren. They're going to come up with some version of this that essentially says you have to prove a racially discriminatory purpose. And what worries me is they're going to say, and it's not a racially discriminatory purpose to diminish the voting strength of Black voters if the reason you're doing that is not because they're Black, but because they're Democrats.
I do want to open it up for questions soon, but before we get there, I want to ask Lindbergh about what you're seeing on the ground in terms of engagement from young voters and the
Yeah, I'll
Ordinance.
answer that quickly. In the material that you have that's online, you can look at, there's a chart that shows registration and voting, black voters. It happens in Mississippi because that's where I am now. The same would be in any other states. And the chart shows the significant, almost straight line up in terms of voter registration following the 1965 Voting Rights Act. And the second chart shows voter participation as compared to eligibility and eligibility to vote and voting. And you'll see a line in one of the charts of the rate of voting, actual voting, being 79% and 83% of eligible voters voting. That's extraordinarily high, as you all know. And you can correlate that to 2008 and 2012. Barack Obama was running for president in 2008 and again in 2012. And you see that. The other years, the line goes down dramatically. And so the rate of participation is a significant problem and continues to be, as it is across the country. And the combination of the rate of participation in voting and all of the things that we have talked about, the attacks on the Voting Rights Act and provisions of it, are not encouraging for our democracy.
Do you think there are lessons from the past that we can draw on to help people re-engage on a practical level?
Very quickly, the answer is yes. But there's also another chart in the material that you'll see. You can't see this. This is League of Women Voters poster about in Mississippi does an annual meet the mayors and see what they have to say about what they're doing, and I help with that sometimes. But the poster, you're looking at this. This is from Vicksburg, Mississippi, Jackson, Mississippi, Canton, Mississippi, and Hattiesburg. All the mayors are black. And this is a photo before the Voting Rights Act from the same cities. All the mayors are white. So that is dramatic kind of evidence of that. And before the Voting Rights Act, we had individual litigation. We have a slide on that. And the NAACP, the ACLU, and other organizations were League of Women Voters all active. We'll have to do that again. As tough as it is, we'll have to do that again. And the other point that I would make, just kind of based on what I'm doing every day and have been doing for the last couple of years, we're in a tough time. We're in a time of extreme backlash now, more than I've seen in my lifetime, and probably most of you, in terms of combination of things, and with the President of the United States, the Supreme Court, and the Congress. But before that, we had an extraordinary time of progress in this country in my lifetime, with the administrations that we have, with the changes that we have, with the Biden administration, the Obama administration, in terms of making this country look more like its citizens. And we have had backlashes from, in response to the Civil War and the Reconstruction Act and the Black Codes and Jim Crow and backlash to 1954 Civil Rights, Brown versus Board of Education throughout. And they've been various strengths and time. This is the most extraordinary, but we had the most extraordinary expansion immediately before the impact that we are seeing now. And that gives me hope that we will have our turn again. And I hope we're smart enough to run as fast and as far as we did just a few years ago, because that's the history of this country. And we cannot stop fighting no matter what.
Let me open it up for questions. If you're, you can ask questions on, for those who are online as well, if you want to put it in the chat. We can
Already
take
told
those
them
too.
they can't. But no question, that was.
Oh, I don't need a mic, I don't
Give
think.
you the microphone, so folks can hear.
I'll just be a talk show host.
Thank you. It's an honor to be here.
I think everybody wants to know, Mr. Porter, are you gonna run for mayor?
The election was in June. The answer was no.
Any other questions?
I'm just curious, for all of you, you've been doing this for a long time and kind of echoing what Lindbergh just said about how you keep hope and faith and what lessons from the past you can look back on and say, we've been in a deep, hard place before and we found a way out. What are the tools you use on a daily basis to give you that faith? And in particular, I'm thinking of the young people that I'm sure we all have in our lives and how to give them some faith that the country we're turning over to them is going to be a place worth living in and fighting for.
I mean, when I teach the 14th Amendment class in particular, I have them look at why do we have the 14th Amendment? What did the 14th Amendment initially do? What did the 15th Amendment initially do? Because I want them to see that the history of voting rights in the United States is not a history that goes like this. It's a history that goes like this. And, and this is, I think, exactly what Lindbergh said, which is people managed to make real progress in the past, and you can make real progress in the future. And, don't lose the commitment to making that progress. And that's, when I talk to the students, I often quote this passage from the Pirkei Avot that says, you're not required to finish the work, but you are required to start it. And, people did this for generations before you, before they saw real progress, but they kept at it. And so you have to keep at it too.
I think Lindbergh and Pam say it so well. At commencement last May, what I said to the students is that we really only have two choices. Either we give up in the face of what's happening, or we have to fight harder. And if you look at it that way, there's really only one choice. We have to fight harder and better than we ever have before. What gives me hope in part is the kind of history that Lindbergh and Pam are talking about, that there have been dark times before and the country has gotten past them because people have worked hard to make it happen. But also what gives me hope is seeing my students every day. They're tremendously idealistic. They're not optimistic at this point in time, but they are very determined to want to use the law for positive social change in this and in other areas.
And I would just add for us, those of us in this room, most of us in this room, some not. This is a fight that our opponents are fighting against the future. And they will not win. The future always prevails. And we are fighting for my grandchildren and their grandchildren. And I don't have a grandchild yet.
I just want to thank the panel. Thank you for being here. If there's a reception.
Yes, for those of you here in